GEO is doing exactly what government officials can do and generally have done, running facilities like this. So imagine you had brought these claims against ICE and specific ICE officials. ICE and the officials could raise sovereign immunity, they could raise qualified immunity and Westfall Act immunity. And if the district court denied any of those, then they could get an interlocutory appeal. So why shouldn't the rule be the same for GEO? Don't the considerations that justify interlocutory appeal when the suit is against a government official also justify an interlocutory appeal here?
I think it depends on the basis for the suit and particularly in the basis for the defense. So the reason that an ICE employee, and I'll note this court has never held that qualified immunity is a defense to forced labor claims, statutory forced labor claims, but I'll bracket that, assume that ICE employees could get qualified immunity or could assert it. The reason they can do that is what this court has said is that the history and the policy support an immunity from suit. And so if the history and policy support an immunity from suit, then you'll get qualified immunity. And what Filarski
All right, well, how about the policy? Why isn't the policy the same, policy considerations the same here?
Sure. So what Filarski and what Mitchell say are the policy considerations that specifically justify the immunity from suit is the consideration of wanting government employees to show initiative in the face of unclear law. That is why you would get qualified immunity. That is not why you get Yearsley. Yearsley, in fact, is precisely the opposite of that. Yearsley only applies when you're doing exactly what the government directed, and it doesn't matter whether it's clearly established or not. Yearsley isn't about saying, contractors, we want you to go out and take bold action, regardless of whether you know it's lawful, regardless of whether you've been directed by the government. And so but
it's not really, the justification for qualified immunity is not just that you want government officials to be able to take bold action. It's that you don't want them to be to have to bear the burdens of litigation, which can be quite substantial, when it may well be that they didn't do anything that was unjustified based on what they knew. So why doesn't that apply just as well here? Those policy considerations, why don't they apply just as well here?
Sure. So I want to distinguish between the policy considerations that underlie a potential defense, like qualified immunity. Those considerations go to the existence of the defense. What Mitchell said is the key to qualified immunity that justifies an immediate appeal is this need to show initiative, and that's just not at issue in Yearsley. And we know that not all government defenses are immediately appealable. Not everything that's going to put a litigation burden on somebody who works with the government is immediately appealable. We know that from Will versus Halleck, the FTCA judgment bar claim. We know that from Swint, which held that Monell claims when a local government is when a plaintiff is trying to hold a local government liable for just the acts of its employees when they haven't satisfied Monell. Swint says no immediate appeal, and that is the government itself. McDonald reaffirms an old Supreme Court case about immunity from prosecution for people who have testified on behalf of the government. The public authority defense in the criminal context, which this court mentioned in the Trump case, that's a defense for people who work with the government. And this court said it's not an immunity from suit, it's a defense, and it's not immediately appealable. And so when we're talking about just the general costs to the government, what we're talking about is something that this court over and over again has said does not justify an immediate appeal. You need something special. And I'm happy to talk more about that, but I also want to flag that everything we're talking about now is policy. And and policy based on empirical questions. How much is this going to cost the government, if anything? What is the impact going to be? We have the government here telling us that the impact doesn't justify an immediate appeal, but if this court thinks that those kinds of considerations might do so, then the proper avenue for considering them is rulemaking, where you can get expertise from the bench and from the bar to explain these empirical questions, to discuss the policy considerations. Because here you have a case.
Policy is a dirty word, but isn't something similar to policy what is going on in Mitchell and in the other cases where we have said there's a right not to be there's a right not to trial unless a certain requirement is met.
I absolutely agree with that, Your Honor. And Mitchell was before Congress passed a statute enabling the court to create new categories of interlocutory orders through rulemaking and interpret the final decision rule through rulemaking. And what this court has said in Swint, what it said in Mohawk, what it said recently in Microsoft is that now is the proper venue for answering this kind of question. Unless we've previously said that something is a collateral order, if we're going back and forth about empirical questions and policy questions, rulemaking is the proper venue for doing that. And then I'd like to just briefly address the idea, the completely separate from the merits prong. You know, again, what this court held in Mitchell is that the thing that makes qualified immunity collateral is that this clearly established law question. And that question is a purely question of law. And we know from Johnson that where you don't have that pure question of law, where you have a question that is there a sufficient dispute of fact to send to the jury, you don't get an immediate appeal. And the way, and I think GEO's argument on this point, as I understand it, is Mitchell held that any time you can answer any questions on given facts, that's sufficient. But that can't be the case. That would mean any order on a motion to dismiss, any order on a motion for summary judgment, the issue in Johnson itself would have been immediately appealable, and we know that's not correct. What makes qualified immunity different is the question, you have to look at given facts to figure out what right is the plaintiff saying is violated here. But the fundamental question is interpreting circuit and Supreme Court precedent to figure out whether a legal right was established at a particular time. That's the ordinary thing appellate courts do every day. Here, there is no equivalent on which Yearsley can be granted to this just interpret appellate and Supreme Court precedent. Yearsley, to get the Yearsley defense, a contractor always has to satisfy the second prong, which is, was the conduct that caused the plaintiff's injury directed by the government? And that is always a factual question that's record intensive. The question is, look at the facts underlying what the contractor did and what caused the plaintiff's injury, and then compare them with a second universe of facts, which is what the government directed, which I'll note is not just in the contract often, but is in handbooks, it can be in emails, it can be verbal, there can be deposition testimony.